Now, on to today's event. A white paper issued by China's State Council on Hong Kong back in June has caused a tremendous amount of debate and anxiety in our city of Hong Kong. The document, when translated into English, stated that the central government had comprehensive jurisdiction over Hong Kong and says that its high degree of autonomy is subject to Beijing's oversights. Many people took this in different ways. Now, the topic of Hong Kong's future is going to heat up again this weekend. Many people are anticipating an announcement from Beijing on whether it will allow democratic polls in Hong Kong. Well, today I'm honored to say we have two speakers here to explain the Beijing view. Wang Zhenmin is a professor of law and dean at the School of Law at Tsinghua University. Jihong is deputy director and constitutional professor at the Institute of Law at the Chinese Academy of Social Sciences. First, Professor Wang will discuss how the white paper relates to the basic law, and Professor Mo will review the relevance of the Chinese Constitution of 1982 to Hong Kong. We will try as well to leave time for Q&A at the end of our speeches. So it's my pleasure to invite Professor Wang to come speak first.
Mr. President, Madam Joseph, friends, ladies, gentlemen, good afternoon. It is a great pleasure and a privilege to be invited by this distinguished institution to speak here today about the white paper and the basic law. Before I came, friends in Beijing reminded me it might be unwise to go to a very sensitive place at a very sensitive moment to speak on a very sensitive topic. Nevertheless, I'm very happy to be here to share you with some of my thoughts on the current debates. Firstly, I would like to make some remarks on the white paper. The white paper is a white paper, not law. Just like the White House is a house, not a palace. Our Chinese language translated as a palace, not house. The white paper just reiterates the long-standing policies, one country, two system policies inherent in the basic law. Nothing more and nothing new. It summarizes the efforts the Chinese government has made since 1997, how the government, what kind of measures the government take to maintain Hong Kong's stability and prosperity. Its main function is to help the Hong Kong society and also the Chinese mainland people to understand the essence, the spirit of one country, two systems. That's the main function. It's a common practice for any government in the world to use white paper to make policy address. Just like the British and American governments, they publish Hong Kong report. The US once a year, the British government twice a year. So it's nothing new, nothing surprising. But the reactions toward the white paper in Hong Kong, some reactions went too far beyond my imagination. To be honest, the white paper, it's just a policy address. The one country, two systems was written into the basic law in 1990. The basic law is current, valid law, cannot be replaced by the white paper. Hong Kong practices rule of law, not rule of paper. not rule of the white paper. So the central authorities and the Hong Kong government will continue, strictly follow the basic law, to implement the basic law without any exception, reservation. As long as the basic law is not revised, not changed, the existing policies will remain unchanged for at least 33 years more. But why are some people so suspicious to the white paper? I propose these three main reasons. First, even the white paper does not change the policies, but the white paper does use some new expressions, new terms. For example, as mentioned by Madam Joseph, the overrule jurisdiction, comprehensive jurisdiction. In Chinese, it's 全面管制权. The overrule jurisdiction or comprehensive jurisdiction actually means sovereignty, nothing new. If you look at the contents, nothing new. Also, the second reason is there are some mistranslations. For example, 治港者, the people who govern Hong Kong, was mistranslated as all those people who administrate Hong Kong. In one place, the 治港者 was even directly translated as administrators. So if you include, judge as administrators, of course, that will cause some confusion. Also, I don't think it's a correct translation. The Chinese language, 中央, the English version translated 中央 as central government or central leadership. In Chinese language, 中央 may means the NPC Standing Committee, not central government. Also, the English version of the white paper omitted important message, important word in describing the judiciary. The Chinese language use 独立, 依法独立行使司法权. Means the judiciary in Hong Kong access judicial power of the region. The English version omitted independently, according to law. So this is a very important, message word, but it was, missed. The English version obviously was prepared by English language specialists, not by lawyers. I suggest you read the Chinese language, the Chinese version first, to grasp the essence of the white paper. In any event, the white paper safeguards the rule of law and the judicial independence. The judiciary is described separately and in parallel or co-equal with the executive and the legislative branches. The three branches are not confused in the white paper. The rule of law with judicial independence is reconfirmed by the white paper. In this sense, the most important reason of the suspicion toward the white paper is the insufficiency of mutual trust between the mainland and some people in Hong Kong. In the past, especially during the Cold War, socialist and capitalist systems were materialistic. After the Cold War, the two systems began to work together and recognize each other's values and contributions to humanity. However, I must say, since handover in 1997, we have not made good progress on confidence building between Hong Kong and the mainland. I must also say the central authorities are sincere in the actions toward Hong Kong. The motherland is like a mother. A mother has no self-interest everything the mother does is for the benefit of her sons and daughters. Mother always acts in the best interests of her children. Her intentions are pure. In this spirit, we need to rationally discuss how to improve our domestic relationship, build mutual confidence. In Hong Kong, after the handover, the rule of law means, first and foremost, the rule of the basic law. This is the essence of rule of law in Hong Kong today. As a matter of fact, the entire China is also seeking to establish full rule of law. Along these lines, I have some good news to share with you. The Communist Party Central Committee has announced it will especially discuss advancing rule of law in the mainland China this October in its fourth plenary session. This represents the first time the Communist Party Central Committee plenary session make rule of law as the main theme to discuss. We're hoping China will establish a full rule of law in the near future. Under such circumstances, the rule of law in Hong Kong will be further enhanced, not be harmed by its motherland, by its mother. Second question, I would make some remarks on the ongoing debate on universal suffrage. China is committed and prepared to develop full democracy in Hong Kong. There are two elements to be considered to achieve universal suffrage. First, Hong Kong's local economic and social situation. Democracy is a political matter. It is also an economic matter. Political system, by its nature, reflects and embodies the economic structure of that political place, particular place. Universal suffrage means the redistribution of economic interests amongst society members. We have to take care of every class, every group of people, every person, rich or poor. No one should be ignored. No one should be left behind, especially those whose slice of pie will be shared by others upon implementation of universal suffrage, which is the business community. Their slice of pie will be shared by the others through universal suffrage. So we have to take full consideration of their concerns. So that's why we require balanced participation. We require nominating committee and functional constituencies. Second, Hong Kong is part of China, not an independent sovereign country. Hong Kong cannot choose its motherland. Just like everyone else, we cannot choose our parents. And China has a unitary government, not a federal government. Under the federal system, there is a saying, all politics is local. You need to go to the local to settle all the political questions. But under the unitary system, like China, all politics is central. The central authorities have the constitutional power and the constitutional obligation to decide on the political system with universal suffrage as its core. Every person is an exception. Every country, every place is also an exemption. Every political system is also an exemption. You cannot find two completely same political systems in the world. For Hong Kong, Hong Kong needs to develop a Hong Kong-style democracy with the framework of the Basic Law. Since Hong Kong cannot change its location, cannot change its motherland, cannot change our parents, we have to find our niche, Hong Kong's new niche, in its new constitutional framework and political structure. Hong Kong democratic development is now at a historical crossroads. We should cherish this very real opportunity. If you consider China had over 2,000 years feudal history without any democracy. So the universal sovereignty in Hong Kong, some people described it's one that may come only once in 1,000 years, 千载难逢. The overwhelming majority of the people in Hong Kong and the central authorities would like to see universal suffrage in 2017. We should not let the people down. We should encourage the central authorities to advance in this correct direction. More is less. Less is more. Less perfect universal suffrage is better than no universal suffrage. Leave some room for future growth. As attributed to Mark Twain, everybody talks about the weather, but nobody can do anything about the weather. We have been talking about universal suffrage for at least 3 decades. Now it's a time to take practical and realistic steps to realize our dream. I will stop here and would like to answer questions and listen to your comments. Thank you very much.
Professor, thank you very much. Before we get to questions and answers, if I could invite Professor Mo to come to the podium to make some comments as well. Thank you.
Thank you, President. Dear President, distinguished guests, and ladies and gentlemen, good afternoon. It's my honor to have a chance here to express my opinion about the constitutional basis for the Hong Kong Special Administrative Region. Maybe most of you are not familiar with my name, and I'm Professor Mo Jihong from the Law Institute of China Academy of Social Science. I'm the constitutionalist. And as a constitutionalist, and I feel, and we should analyze the situation of exercising the basic law in Hong Kong in the constitutional perspective. So why? Because I think in this world, and the constitutionalists have the same idea, have the same thinking way. Because as I grew up in my academic career, just with learning, absorbing the constitutional knowledge from the Western world. So I just remember when I studied in the Beijing University, I read many of the constitutional books written by maybe British famous constitutionalist Edward Bradley, and also some of the constitutional books written by the American professor Norman Dawson, and also maybe Louis Henkin. Yeah. But I think maybe 10 years later, and I met them, and we became the friend. So even now, I participate in the all the activity held by the International Association of Constitutional Law, and in this June, I was elected the Vice President of International Association of Constitutional Law. So now I have very close relation with some Western constitutionalists, and just like the professor, American professor, Harvard University, Tushini, Vicky Jackson, Fleischer, Norman Dawson is my old friend. Also the Edward Bradley, he wrote the Constitutional Law and Administrative Law. It's a very famous book in China. So, generally speaking, when we meet each other and we discuss the constitutional issue, and we find finally as a constitutionalist in the world, we have the same thinking way and the same logic to analyze this is the world. So that's my sense. So today, I just prepare a very long PPT, but I don't try to express all the PPT. I just express at the beginning, the preface, and then the result. Yeah, just very simply. And I think, and it's very difficult for the people and to understand the Chinese Constitution just at the angle of the basic law. But it's very easy to understand the basic law in the constitutional perspective. Why? Because all my result just depend on the constitutional function. So as you know, what's the constitutional function? Sorry. Maybe there are a very famous case in the American. In 1803 years, there are a famous case, Marbury versus Madison. At that time, the Chief Justice of the United States American Supreme Court, Marshall, and he said, when an ordinary law in contradiction with the constitutional law, what will happen? If we apply the ordinary law, the Constitution will disappear. So we should choose the Constitution. Why? Because the Constitution just depends on the will of the people and has the supremacy over all ordinary law. Or in China also, we have the Constitution. So in the preface of the Constitution of 1982, said the Constitution affirms the achievements of the struggles of the Chinese people of all nationality and defines the basic system and the basic task of the state in the legal form. This is the fundamental law of the state and has the supreme legal authority. So that's the Constitution. And how can we understand the Constitution? How can we exercise the Constitution in the whole country? Yeah, this is our constitutionalist task. Yeah, in the both theory and practice. So, in the constitutional perspective, how do we understand and interpret the basic law correctly? Yeah, it's very theoretically. So I agree with Professor Wang. Why our government want to deliver the white paper on the one country, two system policy exercise in the Hong Kong. And we think there, from the 1997 to this year, just 17 years. Yeah. How can we evaluate the efficiency or effectiveness of the basic law applied in Hong Kong? What kind of way? What's our scientific methodology? Yeah, we need a scientific analyzing way. What's the way? The political way? No. The ordinary law? No. Just the constitutional way. So, what's the constitutional way? Maybe in practice, there are some mechanism of constitutional interpretation, just like made in the Supreme Court of the United States of America or several countries' constitutional court. In theory, and also, and there are some the categories of the constitutional interpretation. One of the very important category is the systematically interpretation. And how we use the systematically thinking way to analyze the situation of the basic law applied in the Hong Kong. Yeah, so that's the reason we want to express our theoretical and principle firmness about the situation of the basic law applied in the Hong Kong special administrative region. So we can go through some of the sentences in the white paper. The paper said, we should have a full understanding of the provision of the basic law and all the provision of the basic law underlie the Hong Kong special administrative region system. They are not isolated from, but interrelated with each other. And each of these provisions must be understood in the context of the basic law and the Hong Kong special administrative region system as a whole, the white paper. And then we can see the white paper continue to say, the implementation of the basic law sure that if we comprehend individual provision of the basic law in an isolated way without taking into account the basic law as a whole, stressing one aspect while ignoring others, ambiguity and even contentious interpretation will occur, which will severely hamper the implementation of the basic law. Only by comprehensively understanding all the provisions of the basic law can we find that the Hong Kong special administrative region system, along with all its components, is an integrated whole, complementary to each other, and then this system play the role of the protecting the fundamental rights and freedom of the Hong Kong residents, and ensure the prosperity and stability of the Hong Kong. What can we get from such the presentation? Yeah, I'm a constitutionalist, so I'm very sensitive to such the expression. This is a constitutional interpretation way, very systematic way, and just we want to, comprehensively understand the meaning of the basic law, also the all law in force in the Hong Kong special administrative region. So that's my opinion. I can give an example, just like, you can see the Article 11 and Article 18. We should put them together, and then we can understand what's the meaning. The laws in force in the Hong Kong. I'm not quite sure, maybe 10 years ago, I read some of the paper written by some of the Hong Kong people that said that only the basic law of the Hong Kong administrative region had the legal force in the Hong Kong. I feel very strange. Why? Because even for the basic law, and we can find the different expression, stipulation. So we should combine the different article, and then we can get a full picture. So the Article 11 said, we can see, in accordance with Article 31 of the Constitution, the system of policy practiced in Hong Kong should be based on the provision of this law. Yeah. And then that's the meaning. And that the basic law is the core of the law in force exercised in Hong Kong, but not the Solomon, unique, just the core. And we can see the Article 18. Yeah, the Article 18, it's very clear said that the exceptional situation, maybe the Section 2, the Standing Committee of National People's Congress may add to and delete from the list of the law in Annex 3 after consulting its Committee for the Basic Law of the Hong Kong Special Administrative Region and the Government of Region law. Law listed in the Annex 3 to this law should be confined to those relating to defense and foreign affairs, here very important, as well as other matters outside the limits of the autonomy of the region as specified by this law. What's the meaning? Except the law concerning the autonomous affairs of the Hong Kong Special Administrative Region, there are still some public affairs, just beyond the defense and the diplomatic affairs. Such affairs can't be decided by the Hong Kong, and such the law should be determined, and such the public affairs should be determined by the NPC of the central authority. So we can combine the Article 11 and Article 18 in the constitutional perspective, and we can get a comprehensive picture about the law in force exercised in the Hong Kong. So I just give my consequences. There, here, the chart. Okay, this way. Here, the law system of the Hong Kong Special Administrative Region is my personal contribution, not official. I'm a constitutionalist, the theoretical analysis. At the top, the Constitution of 1982. Yeah. And also the interpretation to the Constitution at the top is the highest, the law, with the highest, the legal force over the Hong Kong. The second, the level, there are several. The core is the basic law. And then interpretation on the basic law also at the second level. And also, now the 12 laws adopted by MPC and the Standing Committee just put into the Annex 3, also at the second level. And also the decision of the other law made by the MPC and the MPC Standing Committee. So at the second level, there are many laws which can be applied in the Hong Kong. At the third level, you can see just law adopted by the Legislative Council in the Hong Kong. And also another category, just the law previously in force without contravening the basic law. So here it's very clear. And somebody think, in Hong Kong we have the traditional culture of the rule of law, but we should distinguish two conceptions. And before 1997, in Hong Kong, there's a common law tradition. But after the Hong Kong returning to China, after 1997, and we have the new principle of rule of law. Here is law, is a basic law, is the Hong Kong administrative region's law. And although and some of the law previously in force, which can be accepted by the MPC Standing Committee, but after the MPC Standing Committee accept such original law, and such original law just become one part of the law system of the Hong Kong Special Administrative Region. So here, and if we said, according to rule of law to govern the Hong Kong, that's meaning according to the rule of the Hong Kong, the new law, not the common law. But there are no contradiction between the Hong Kong's law and the former common law. Why? Because through the legislative procedure, the Standing Committee of the MPC just confirm the legal effect of the original law, such law previously in force in the Hong Kong. So here we can distinguish such two conceptions. Now I just the final word I can give you, and how can we get a comprehensive, correct understanding of the basic law exercised in Hong Kong? If we can think just above the basic law, there are some the block of the constitutional principle, and we can understand the situation of the basic law exercised in Hong Kong very well. The block of constitutional principle include the code of the Constitution, the formal amendments, and the law adopted by the Standing Committee of MPC, and also the basic law adopted by MPC. Also here, interpretation on the Constitution and the all law made by Standing Committee of MPC. I can give an example, final word. Final word, you can see here, the interpretation of 2011 years made by the Standing Committee of MPC. In this the interpretation, how the MPC Standing Committee say, you can see, in accordance with Article 89, subsection 9, the Constitution, the State Council, that is, the central government has the power to conduct foreign affairs and conclude the treaties and the agreement with the foreign states. And the state immunity belongs to the foreign affairs. And the central government have has the power to decide on the policy of the state immunity by exercise of the policy in China. What's this? This is the constitutional interpretation. So in this interpretation of 2011, this interpretation is a mixture of the constitutional interpretation and the interpretation on basic law. So that's my opinion. Thank you.
Professor, thank you very much. We're very close to 2 o'clock, but I know there's interest in this topic, so we will go a little bit over time and take some questions from the audience. So who would like to go first? Over here. And please give us your name and also to whom you would like to address the question.
My name is Martin Lee. I was one of the drafters of the Basic Law for Hong Kong. So I know something about the Basic Law. Now, the problem about the white paper is this sentence. They talk about administrators of Hong Kong, and they say all those who administrate Hong Kong, including the chief executive and others, and judges of the courts at different levels, and other judicial personnel, have on their shoulders the responsibility of correctly understanding and implementing the Basic Law of, here, safeguarding the country's, China's, sovereignty, security, and development interests, and of ensuring the long-term prosperity and stability of Hong Kong. So our Hong Kong judges are looked upon as administrators. Not only that, but they have the responsibility of being responsible when they are trying cases, no doubt, of looking after the country's sovereignty, security, and development interests. How could a Hong Kong judge be expected to do that? And that is what, I'm afraid, the central government calls love the country and love Hong Kong. Judges, of course, are loyal to the country in the sense that they are Hong Kong citizens, a lot of them. They are Hong Kong people. They have taken the oath of allegiance to serve Hong Kong, the Hong Kong Special Administrative Region. They have not taken the oath to serve the interests of China. And supposing there's conflict of interest over the Basic Law, over political development, what does the judge do? He is now required by the white paper to look after the interests of China. And that is the problem. And if you say, Professor Wang, that there are mistakes in the translation, I thank you for that. Please correct them, because it's very worrying to Hong Kong. Thank you.
Response to that?
On the mistranslation question, I think I already speak my opinion. On the questions how Hong Kong judges should safeguard the national sovereignty, security, and development interests. I think it's a new issue for Hong Kong judiciary. Hong Kong judiciary is a judiciary of Hong Kong, and also Hong Kong judiciary is a judiciary of China. It is a constitutional obligation for all institutions in Hong Kong, public institutions, including the executive, the legislative, and the judiciary, to safeguard national sovereignty, security interests. I think the why in 1997, July 1st, the name of Hong Kong government before the name added the People's Republic of China. The reason is, the constitutional law changed. The law remained unchanged, but the constitutional law changed. Before 1997, it's letters patent, a real instruction as Hong Kong's constitutional law. So at that time, Hong Kong judiciary need to safeguard British interest before the handover. No problem. But after handover, Hong Kong, why I mentioned Hong Kong is not an independent sovereignty. It's part of a sovereign country. So it's a constitutional obligation, to safeguard the national interest, national security. That's no problem. I think, Martin, your Chinese language is much better than mine. You can read the Chinese version. On this question, the English translation, there is no problem. It's the same. It's same meaning. I think Professor Ji has.
I want to supplement several words and to make the deep understanding about your question. I think if we want to answer your question correctly, comprehensively, and we should take such the two questions as the premise to answer your question. And how can we interpret the meaning of the Article 2 and Article 158, the meaning very well, correctly. The Article 2 said, and the central authority authorized the Hong Kong special administrative region to have the legislative, the executive, the judicial, the power. So here, there is a question, where does the judicial power shared by the Hong Kong special administrative region court come from? If you can answer this question, and then, I can think some answer, can come out. And the second premise, just how can we understand Article 158? 158 and said, and the Standing Committee of NPC can have the power to interpret the basic law, and also can authorize the Hong Kong's court, especially maybe the final peer, to have some power to interpret the basic law concerning the Hong Kong administrative owning affairs. Here you can find in this article also said if the final peer just find some affairs beyond the control of the Hong Kong special administrative region, so the final peer should submit such a problem and to the Standing Committee and NPC to ask for the further of the clear interpretation. Here we can find, just like the interpretation of 2011, the final peer submit such the problem to the Standing Committee of the NPC. What's the issue? Just the state immunity. The state immunity, connect with the state sovereignty. So here, I think the peer just did very correctly. So we can find, and if the court in the Hong Kong special administrative region, and they can apply the basic law very correctly, so, and they can play a very important role in safeguarding the state sovereignty. So that's my supplementary idea.
Thank you. We have time for one or two more questions. Over here, gentlemen.
My name is Paul Zimmerman, and I've adopted China as my mother, so we can talk about mothers maybe. As I gave up my passport, I'm now a Chinese citizen. Many people are very concerned about mother. They find mother somewhat erratic. She doesn't allow people to speak freely. She doesn't allow people to organize freely. And some people in Hong Kong, others who have never had a choice of choosing their mother, are very worried about that. And they're worried, and they like to see universal suffrage as a way to protect them against erratic behavior of mother. People are also worried about the business interest of mother. And they're also worried about the business interest of the tycoons in Hong Kong, and they like to see universal suffrage as a way of protecting themselves against that. Now, Mr. Wang, in your statement, you suggested that we could not have universal suffrage entirely, but we needed to accept fake democracy, as I've been handed this little paper saying no fake democracy. Because you had to protect the business interest, and if we just had universal suffrage, then we were going to splice up the business interest and they were not properly represented anymore. Could you further explain that as a reason for fake democracy, please?
As I said, China is ready to realize universal sovereignty in Hong Kong. The attitude, the approach of the central government is very clear. But no 100% democracy in the world. No country, no place can claim their democracy is 100%. You cannot only have a perfect democracy in the beginning. Just like the political system of the American, established by the American Constitution, in the beginning, it was not perfect. It had slavery. The black Americans didn't enjoy right to vote. The women didn't enjoy right to vote. The Constitution was imperfect, but the American people accepted the imperfect Constitution, imperfect political system, and they implement the Constitution, gradually improve the democracy. I think Hong Kong is in the beginning of democracy. We start from zero. You cannot expect in the very beginning you have a perfect universal suffrage, perfect democracy in Hong Kong. You couldn't have a perfect democracy in the US in the beginning, in the UK. How could you expect? In the very beginning, Hong Kong had a perfect democracy, perfect universal suffrage. We must be realistic and practical. I think the Hong Kong and the Chinese people, we need to think about how to develop a Hong Kong-style democracy can settle the questions of Hong Kong.
Okay.
We have a question from the center here.
I have one word.
Okay.
And if we look at the document, International Human Rights, and we can see just like the two main international treaty of human rights, just like the CCTR. The CCTR stipulates many kinds of the human rights, but the subjective of the human rights, the document said just anybody, anyone, without any limits of the nationality, but only for the right to participate in the public affairs. Just the Article 25 said a citizen can have the power, can have a right to participate in the public affairs. Here we can find only, even for the CCPRs, the international criterion for the human rights, and just only admit, only accept, only the state citizen can have the right to vote or to be elected, or act as a candidate. So here, and we can analyze, the Hong Kong's universal suffrage, and compare to other countries' universal suffrage. I'm not quite sure whether we can find a second country can accept the foreigner can participate in the universal suffrage. So here, it's very typical. It's obvious for the Hong Kong. If we have the universal suffrage, it will erect an example for international society. Thank you.
We have a question in the center here, right here. And then we'll wind up with Francis. Please go ahead.
Hi, my name is Andrew Davis. I'm just curious, you seem, Professor Wang, to almost to indicate that the Chinese government seems surprised by the reaction to the white paper, which you kind of indicated is just your typical policy study, the kind of thing often done by mid-level bureaucrats, and this is done typically by governments. But could that really be the case given the timing of the release and the sensitivity of this issue? I mean, it was just dropped a few weeks ago coming into the NBC meeting. Sorry. And also, is it really possible to think that such a sensitive document wouldn't have been scrutinized by some detailed legal, with people with detailed legal background in terms of the English in a bilingual city like Hong Kong? It sounds very surprising that we're hearing about these translation issues 5 or 6 weeks afterwards. I'm just curious.
Thank you for the question. As for the timing, as I said, to use a white paper to express policy is a common practice in the world. Many governments issued white papers. As for the timing, I don't think the Chinese government especially chose, June to publish the white paper. It's just that the white paper was ready at that time. So it's no special, meaning, special consideration on the timing. As for the English translation, to be honest, the English version was really done by language specialists, not by lawyers. I don't know who did the final review. On the basic law, the English version by the basic law, it is a, official and legal translation, passed by the National People's Congress, same time with the Chinese version. So only the basic law has, official and legal translation. All the other laws, including government papers, official papers, were not, there's no official, very legally considered, translation. That's the reality. I think in future, I would suggest the Chinese government employ Professor Ji and me to be their advisors on the English versions. And we can also seek your opinion on the English version. Thank you.
Francis, I'll go to you, and then we have one last question on the veranda. Francis?
Francis Moriarty, freelance. Professor Wang, we heard you speak earlier about universal suffrage in 2017, saying that a little bit of universal suffrage would be better than no universal suffrage. So my question goes to defining terms. Does universal suffrage mean to you only that each individual over the age of majority has a vote? Or does universal suffrage mean to you something more than that? And if so, what?
My understanding on universal suffrage is to guarantee one people, one vote, and every vote enjoys same value. The entire process of universal suffrage has several phases. The nominating phase, the general vote, the second stage. As long as every person is guaranteed to have the right to vote in the second stage, I think that's the universal suffrage. That meet the requirement of international covenant on human rights. On the nominating stage, I think every country, every place has different nominating mechanism. There is no international covenant on political system, on universal suffrage. So far, no international community, including United Nations, ever tries to enact an international covenant on universal suffrage. So on the contrary, the United Nations Charter says every country is entitled to practice its own political system, to make its own laws on political matters. So that's the part of the national sovereignty. Of course, this is the first stage, the beginning stage of universal suffrage. We have room to change in the future. the first step is very important. If we cannot take off the first step, we cannot see the future. So this is a very important critical historical moment for Hong Kong to take off the first step. Thank you.
We have time for one last question. Did you want to add to that?
Yeah, I can supplement some of the opinion. And for the understanding the meaning of the universal suffrage, and we can go through the general comments 25 made by the Human Rights Committee, just interpret the meaning of the Article 25 of the CCPR. There, many understanding. But I think this is the international criteria. Just the Human Rights Committee persuaded the state party when they submitted their report. They should pay attention to such the main points. So they are very important idea, just without any unreasonable restriction. So this is very important. What's the meaning unreasonable? So for the candidate and for the vote here, and yeah, I'm a constitutionalist. Also, I'm familiar with the election theory. And if some nomination procedure, and you can predict the nominated result before we start our nomination here, this is the false nomination. But all the people, and they are equal in front of the nominating procedure. Here we can see just the real nomination. So, and some people maybe think we should have some people represent us and can be elected as the candidate. Yeah, what's your reason? Yeah, what's your evidence? What's your people's will basis? Yeah, you should verify through your activity. So we think, and we should become more and reasonable, and we can understand each other very well. Thank you.
I'm sorry that we've run out of time. We have time for one last question back here, and I do hope we'll have time for individual Q&A afterwards, please.
Thanks. I'll keep it short. I'm Mike Forsyth from the New York Times. Professor Wang, like many of us, we're about to go file a story. We're reporters. I want to make sure I've got this correct. You said that one of the reasons that you don't want to change the nominating committee in Hong Kong too much is to protect the interests of the business class in China, that their slice of the pie, it would be eroded by universal suffrage. Is it correct that I'm saying that the communist government in Beijing wants to protect the interests of the capitalist class in Hong Kong, and that's why we can't change the nominating committee? That's why the democracy is going to be imperfect? Is that correct? Because if it is, that's pretty amazing.
To answer your question, I need at least 1 hour. Because this is a very complicated issue. As you know, the Communist Party in nature originally represents only the people, not representing the billionaire, the business people in history. However, in 2002, the Communist Party changed its charter, and later on China changed its constitution. The Communist Party, on the one hand, continued to represent the general public, the farmers, the workers, as its basis. On the other hand, the Communist Party began to represent the rich people, the new business community in mainland China. So on the one hand, the Communist Party continued to represent the poor, the workers and the farmers. On the other hand, represent the rich. So that's a big change in Communist Party theory and also in Chinese constitutional law. I think in Hong Kong, it's same. It's same. In history, the business community was the enemy of the Communist Party, always against the rich. But now the Communist Party is the ruling party. The Communist Party must take into account of all classes, the rich and the poor. So that's why in implementing universal suffrage in Hong Kong, on the one hand, we must consider the interest of the general public. the ordinary, the middle class in Hong Kong, the ordinary people in Hong Kong, that's no problem. That's why China permits Hong Kong to implement universal suffrage. But on the other hand, the business community is a reality. Even it's a small group of people, a very small group of people, elite people in Hong Kong, but they control the destiny of the economy in Hong Kong. If we just ignore their interest, the Hong Kong capitalism will stop. So that's why, on the one hand, we realize universal democracy, universal suffrage in Hong Kong. On the other hand, we must guarantee the continuing development of capitalism in Hong Kong. Thank you.
Thank you.
Professor
I just supplement some more. I think there is a very useful legal principle, a rule of law, can answer your question very well and also consider very comprehensively. And there are just proportionality. I think maybe among you, you're a jurist or lawyer. The proportionality is a very important principle of law, just in the continental law. And this the principle is very useful for the judge, also for the public official. And when they make the public policy, and they should combine all kinds of the factors together, and then decide and how to apply the policy and the law. So the proportionality, I think this principle also can be applied to the universal suffrage, and we can get the comprehensive, completed understanding. Thank you.
I'm afraid we're going to leave it there. It's now 2:30. Professor, I'd like to thank you very much for coming today, and thanks to everyone in the audience. Have a good afternoon.